let's see. On the record in the matter of the people of the state of Michigan versus Carlos Diaz Torrens 24-01062. Do not believe he has an attorney representing him at this time. Mr. Torrens,
Yes, ma'am.
can you hear me?
Yes, ma'am.
Okay, this was set for a review at my request by your probation officer because you've been in custody, it says, since July 29th. Is that accurate?
Yes, ma'am.
Okay, and you're being held, are you waiting a trial? Is that what's going on?
Yes, ma'am.
Okay, so you were not able to complete the terms of your probation before this court. What I think I'm going to just have to do is to discharge you unsuccessfully and terminate your probation status, okay?
Okay.
You did not, so it doesn't show that you owed a balance, so you're all set.
Now, what would happen with do I just do the time instead? Do I get,
Well, you're being held anyway, so we're just gonna discharge your probation status and you'll just be waiting on the other matter that you have pending. But as it relates to this case, it's gonna be resolved. You've been in custody since the 29th. You were supposed to be off of probation on the 21st of June. So you've maxed out even any time I could have served you on this at this point, okay? So you're all set.
thank you. Thank you.
You're okay to leave the room, sir. He's got final pre-trials next week in full.
Mess stuff up.
One next week.
Getting stuff on. Let's see here. Ray's out of custody. That's what it said. Who's out of custody?
Mr. Ray.
Oh. Germinal. Mr. Harrison Jefferson.
Yes.
Okay, on the record in the matter of the state of Michigan versus Harrison Jefferson the third 25-03176. Appearance, please.
Jeffrey Dillabay on behalf of the people.
Jacob Riley on behalf of Mr. Jefferson, who's present to my right.
Okay, Mr. Jefferson, thank you for appearing so promptly. I did discuss with you prior to your appearance that there's been a bond violation reported. It's a serious violation. The allegations were that you had contact with the protected party and that it was violent contact, that you struck her in the face and pointed a firearm at her. Officers alleged that there was cameras in the area and that they have photos of the injuries. And so my original intention was to just remand you, but since you were so prompt in getting here and taking care of your business, I'm going to release you on GPS tether. Okay, so you can get back to work. I'm going to remind you though, that you're not to have contact directly or indirectly for any reason with the protected party, that person being a Natalie Hatley. Do you understand that?
Yes.
You're not to have any phone calls, any text messages, any DMs, any Instagrams, any Snapchats, letters. Don't drive by their house. If they're at Kroger, you go to Meijer. You understand that?
Yeah.
What I'm going to do is set this for a bond violation hearing, because as to the violation, you have the right to have a contested hearing and the right to have witnesses called to determine whether or not you did in fact violate the conditions of your release from custody. If you're found to be in violation, your bond can and more likely than not will be revoked pending the outcome in this matter. But also a bond violation is a contempt of court. So that means you could face up to 93 days in jail for that. You understand that?
Yes.
Okay, so the court will enter a plea of not guilty on your behalf for that purpose as it relates to the underlying domestic violence. Was there an offer at this time?
None, Your Honor.
Defense would request final pretrial date.
Final pretrial, December 15th at 8 a.m. That's P 53 is that day too, and then jury trial, February 3rd at 8 a.m. You got those dates, sir?
Yeah, and then could they get mailed to me?
We're gonna give you a notice when you leave here today to take with you. December 15th will be your next court date. You must appear in person, and then February 3rd, you must appear in person. And then your attorney has accurate contact information for you, correct?
Yes, Your Honor.
So you'll get your tether and then you'll be free to be released back on bond. Any additional matters for the record?
None from the people, Your Honor.
No, Your Honor.
Thank you. Okay. Okay, it might be still coming. Let's just have the first one first.
Yeah.
Okay,
Thank you so much.
no problem. This was this one in this file.
Do you want, on the form of use, right?
Correct.
Okay.
And the alternative is for him to go up there and get it. Tell us what you're saying.
If you go out to Mesa, well,
Because if I do it before he has release, he has to be transported.
yeah,
Otherwise, he could leave and go to JFG and get a tenant.
yeah,
I think I can trust him to do that. He brought himself in here.
okay,
That's correct, Mr. Jefferson.
yes,
You need to go directly from here to get your tether. That's in lieu of me sending you to the jail first, okay?
okay.
Okay, and we have Mr. Ray, on the record in the matter of the state of Michigan versus Caleb Ray, 25-00803, appearance, please.
Jeffrey Bill, on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Ray, who's standing to my right.
I'm just reading the update from Mr. Hannah.
Yeah.
Okay. Says that Mr. Ray's been making great progress.
Yes, ma'am.
And the real issue is just all these court dates. You got some other stuff confusing you or something? Is that what's going on? Or tying up your time, I should say?
You work, right? And then you got classes and everything going on with probation. So I think it's just when he can manage, when he's got just probation in his classes, he manages both. Courts throws an extra wrench in the works. So I think everyone's eager to just get him back into his programming, work on probation, so he can handle both of that and work without having to keep coming back and calling off for days.
So he enrolled in the required programming? He's all otherwise compliant?
That's my understanding, yes.
I think I said that if he did that, I would continue his probation.
I believe that was the conversation, Your Honor, and then I think you reset from 2 weeks ago to today just to see what Judge Flores decided in the probation case there last week. He did his 5 days and he's back in working with Mr. Hannah now.
He pled guilty to violation number 6. Is that what happened?
I believe that was the number, yes.
I'm sorry, number 14. Dismiss violation 13 and 12. I mean 3 and 12. Okay, I'll continue his probation at this time.
Thank you, Your Honor.
Happy to hear that you're back on track and that you'll remain on track. If for some reason you run into some challenges, your best recourse is to contact your probation officer and communicate that, okay?
Yes, ma'am.
All right, do you have any questions at this time?
Amen.
Any additional matters, counsel?
Nothing from the people, Your Honor.
Nothing further, thank you.
Thank you.
It's not just you. It's like they gave up after Matt.
The way that it printed it is-
Thank you. No, thank you. You've
Yeah.
done more, you've done more than enough. Thank you.
Yeah.
I appreciate it.
Right. Oh, David, is there someone else in custody?
Yes.
Yeah. You can bring the next person up.
I'm sorry.
You can bring the last person up in custody.
Pardon, Edward.
Harvey Edwards, okay.
Yeah. I will admit, Your Honor, I have no idea whether that's a contested hearing. I met with him on Friday. He got very upset and exited our conversation early.
Today.
He did make,
We said Gino Garcia is not here, so we said.
no one answered when I called his
Oh.
name. He had a few comments to me about serving the time, so that may mean he wants to play to it, but he got upset and walked out, so I don't actually know.
Alright, okay, this is Mr. Oh, honey. On the record in the matter of the people of the state of Michigan versus Harvey Edwards, 25-00552 FY. Appearance.
Jeffrey Billabong on behalf of the people, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Edwards, who's standing to my right.
Mr. Edwards has a probation violation scheduled for today. Let's see here. The what status is outstanding? It has been. I have a violation that's from August. It says the defendant never reported to sign his probation orders and he absconded from probation. How we proceed with this?
Your Honor, I'll defer to my client whether or not he wishes to contest the violation or admit to it. Mr. Edwards, you have to advise the court whether you'd like to contest that violation or admit it, or admit that it's true. I'm so sorry, can you speak up just a little bit?
True.
It's true. So you'd like to admit to the violation?
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Is that a yes?
No.
Okay, you have the right to have a contested hearing and the right to have the prosecution put forth evidence to establish whether or not you violated the terms and conditions of your probation status. You understand that? Is that a yes? Anyone threatening you to waive your hearing and plead guilty? Any promises if you plead guilty to the violations? What's the promise?
I mean, say-
Okay, you meant to say no? No promises? Okay, as to the violation that you absconded from probation, how do you plead? Factual basis.
Thank you. Mr. Edwards, is it true that in May of this year, you underwent sentencing in front of Judge Simmons? I think you have to speak up just a little bit more with microphones. And during that sentencing, did she put you on a term of probation?
Yes.
And during that, did she tell you to go to probation and sign your orders with them?
Mhm. What's in it?
With probation, you're in this building.
Oh, no. That was,
So you were supposed to go on a term of probation, right?
Yeah, I didn't know. I went to say.
Okay. And so you didn't come back to probation, right?
No, I didn't come here. No.
And it's true that as of today, you still haven't come back to probation, right?
I came here one time, but he said he called me something. But I remember that.
And but he'd already submitted this violation.
Yes.
Okay. And I believe that.
I came here one time. That's it.
Okay. And I
And that's
believe.
what I kept saying.
For at least purposes of the factual basis, I believe that satisfies.
Any question from the prosecution?
The people are satisfied. Your Honor.
Finding your pleading needs sufficiently made and the factual basis is satisfied. Your plea is free, voluntarily and intelligently made. The recommendation is to terminate and to sentence the defendant to jail. It says the defendant made no attempts to contact probation. It says he didn't have a phone, but he was provided with resources to get a government phone. From that point, he never heard, he being your probation officer, never heard from you again. It is clear probation is not appropriate for Mr. Edwards. You can address the court on sentence.
Thank you, Your Honor. I believe there are a couple of updates for Mr. Edwards here. Fully acknowledging it's not going to change the ultimate conclusion here, but just for his sake, he did continue working with CMH. It looks like he did come to the court at least once to try and make contact. It was too little, too late. It was already occurring after these violations were submitted and prepared by Mr. Neves. He did continue with CMH. He continued attending AA meetings on his own. However, that's acknowledging that that wasn't the way he was supposed to be completing things. He was supposed to be doing them with probation under the supervision of the court here. So I think we all can acknowledge didn't go about this the right way. I would ask the court to adopt the recommendation here. I would suggest a term of 90 days here. I understand the maximum potential is a little bit higher here. He does have another case before the 55th District Court as of right now that I believe is going to hold him in custody for a while, Your Honor, given the nature of the charge and the bond in that case. So even if the court was to consider a shorter period of time, he's not being released any shorter. That would be my request of the court today.
Yeah, the issue is I'm looking at the judgment of sentence. He's already been sentenced to 365 days with credit for 74. At least that was the sentence at the time that I sentenced him, and I said I would suspend the balance upon successful completion of probation. So he's got to serve the remaining balance of that.
And I'd just like to note, Your Honor, that the balance has gone up a little bit now, given some time in custody.
And credit time.
Thank you,
Give
Your
him
Honor.
credit time served for whatever he's served. I don't know. He's been in custody in this since October 23rd or 22nd.
22nd, I think, Your Honor, but
He
it's,
he refused to leave the cell on the 22nd.
I believe that's correct.
Give him credit for a total of 95 days. And serve the balance of his original sentence. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing further, Your Honor.
I'll waive the 475. That's probably just oversight. Please.
I believe so. And then fines. Thank you. Appreciate it, Your Honor.
Thank you. You're all set. Ms. Marquita need something? Oh.
Good luck to you.
Oh.